Understanding promissory notes in California is essential for anyone lending or borrowing money. These legally binding documents establish the terms of a loan and provide protection for both parties involved. California recognizes two types of promissory notes: secured and unsecured. Secured notes provide greater protection for lenders by attaching collateral to the loan, while unsecured notes rely solely on the borrower's promise to repay. For a California promissory note to be legally enforceable, it must include several essential elements. These include the names and addresses of both the borrower and lender, the principal loan amount, the applicable interest rate, and detailed repayment terms. The document must also specify any late fees or penalties for missed payments and must be signed by all involved parties. California imposes strict usury laws that limit interest rates on personal loans to 10% annually in most cases. However, certain financial institutions like banks and credit unions may be exempt from these limits. Charging interest above the legal limit can result in penalties, including the forfeiture of all interest earned on the loan. When writing a secured promissory note, you must begin by entering complete information for both the lender and borrower, including the current date, loan amount, and interest rate. You then need to specify the repayment method, which could be a single payment, installments, or interest-only payments until the balance is paid in full. The note should clearly describe the collateral being used to secure the loan. This could be real estate, business assets, or personal property. For non-real estate assets, filing a UCC-1 financing statement with the California Secretary of State is necessary to properly secure the loan. For unsecured promissory notes, the process is similar, but without the collateral section. These notes carry more risk for lenders since there is no guaranteed way to recover the loan if the borrower defaults. The document should still include complete information for both parties, repayment terms, late fee provisions, and acceleration clauses. Both types of notes should include sections addressing default interest, payment terms, acceleration clauses, attorney costs, and governing law. These sections protect the lender by establishing what happens if the borrower fails to meet their obligations. If a borrower defaults on a promissory note, the lender has several options for enforcement. For secured notes, the lender can claim the pledged collateral without necessarily pursuing a lawsuit. For unsecured notes, the lender typically needs to send a demand letter before filing a lawsuit for breach of contract in a California civil court. After securing a judgment, lenders may be able to garnish wages or place liens against property. In some cases, negotiating a settlement might be preferable to lengthy litigation. Bankruptcy adds another layer of complexity to promissory notes. Secured creditors have priority in bankruptcy proceedings and may claim the pledged collateral before unsecured creditors receive any payment. Unsecured creditors must file a claim with the bankruptcy court, but often receive little or no repayment. Some debts may be discharged entirely, making them uncollectible. While oral promissory notes can be enforceable in some cases, written agreements always provide stronger legal protection. A properly documented promissory note clearly outlines all terms and conditions, preventing misunderstandings and disputes. California promissory notes serve as important financial tools that add security and structure to lending arrangements. By understanding the requirements and implications of both secured and unsecured notes, borrowers and lenders can protect their interests and ensure compliance with state law.